Welcome to this explainer. All right, let's just dive right into it. Today, we're unpacking what you might call the ultimate operating system that runs our entire government machinery. It's called administrative law. Now, if you've ever wondered how the massive gears of the state keep turning without, completely running us over, you are absolutely in the right place. We're going to explore the core principles that govern the governors, that invisible rule book keeping the state in check.
So right off the bat, we have to ask a pretty massive question. Who exactly polices the government? It's a fascinating paradox, really. Think about it. We completely rely on this massive modern state to function. It taxes our hard-earned income, it dictates the zoning of our neighborhoods, runs Social Security, and it even has the extraordinary power to detain citizens and take away their physical freedom. With stakes literally that high, what stops the state from just doing whatever it wants? How do we actually make sure this immense power isn't abused or wielded tyrannically?
Well, here's our roadmap for figuring that out. We're going to cover the problem of state power, what administrative law actually is, the core constitutional principles, the rules of fairness, checking power through judicial review, and finally, the limits of the law.
Starting off with Section 1, the problem of state power and the sheer scale of government. Just take a second and think about your daily life. The state's reach is everywhere. It extends from building the very roads you drive on to work, to managing the public education your kids receive, to regulating the markets where you buy your groceries. It ensures the safety of the medicine in your cabinet, commands the police forces, oversees the prisons, and even dictates who gets a license to practice medicine or open a restaurant. Because the government's reach touches almost every single aspect of society, there absolutely must be a strict rulebook. We simply can't have executive institutions acting on a whim. The potential for damage is just way too profound.
Moving to Section 2, what is administrative law? Let's define the shield.
Okay, so there's a really clear divide in the legal universe. Over in the realm of private law, you have citizen versus citizen. Things like business contracts, personal injury torts, or property boundary disputes between neighbors. But then on the flip side, we have public law, which imposes duties to serve the public interest. When the state denies your zoning permit for a new house or revokes a medical license, that is public law. Administrative law falls strictly under this umbrella. It's the law of the administration. It's the state versus the citizen.
And the absolutely crucial takeaway here is this. Administrative law is the constitutional shield of the citizen. It is definitely not just some boring, unified scheme of bureaucratic regulations sitting in a dusty filing cabinet somewhere. No, it's a living, complex body of legal standards that forces executive institutions to actually use their powers responsibly. Without it, the modern state would essentially operate as a dictatorship of bureaucrats. They'd be making unilateral decisions about your life, your liberty, and your property without any oversight, transparency, or even a required justification. This branch of law is literally what levels the playing field.
All right, Section 3, the core constitutional principles, the foundational pillars of the system.
These four principles are the absolute heavy hitters. They're the interwoven pillars that prevent the government from acting irresponsibly. First, we have the rule of law, which we're going to unpack in just a second. Then, we have accountability. This fundamentally requires public authorities to justify their conduct. They can't just say because I said so. They actually have to provide a legal and rational basis for their actions. Next is comity, which is essentially institutional respect. It's the idea that courts and agencies need to respect each other's constitutional functions, rather than constantly fighting for supremacy. And of course, the separation of powers. This ensures that the people making the laws, enforcing the laws, and judging the laws aren't the exact same people, which creates a natural system of checks and balances. Together, these principles stand as a formidable wall against arbitrary government.
Let's dive a bit deeper into the rule of law, because explaining this principle is really the core task of administrative law. Public officials are strictly bound by the law. They have zero discretion to just violate or suspend it. Even in matters of national defense, where the government has vast prerogative powers to protect the country, they can't simply raise taxes or conscript citizens into the military without the legislature officially authorizing it by statute. And notice something important here. The rule of law isn't just about written standards. It fundamentally requires due process. That means not just following the letter of the law, but executing it fairly, transparently, and consistently so that citizens are treated with basic dignity.
Which brings us to Section 4, the rules of fairness and their everyday applications.
To really understand fairness, we have to look back to this incredible historical quote from the 1700s. Justice Fortescue wrote that even God himself did not pass sentence upon Adam before he was called upon to make his defense.
It's such a punchy line, right? And it vividly illustrates the most universal rule of fairness in administrative law. You always have the right to a fair hearing. Before a public authority makes a decision against you, whether that's firing you from a public sector job or tearing down your property to build a highway, you have a fundamental, basic right to present your case and be heard.
Now, we have to recognize a massive difference between arbitrary power and discretionary power. Arbitrary power is totally open-ended. It's an official acting on a whim without any limits, maybe deciding they just don't like you. Courts will strike that down immediately. But discretionary power, that is entirely allowed. Why? Because it operates within identifiable legal limits. Think of it like this. The legislature gives an agency a specific sandbox to play in. The essence of discretion is that it's contained within that box. You might not get the outcome you want. Your application might still be denied for totally valid reasons, but the official must act within the strict boundaries and intent of the law, not based on their own personal feelings.
Moving right along to Section 5, checking power through judicial review.
But what actually happens when an official steps outside those boundaries? Well, let's walk through this simple 1-2-3 checklist. When a government body acts beyond its legal power, it's called acting ultra vires. And they can do this in 3 main ways. 1, substantive. They just flat out do the wrong thing that the statute doesn't allow, like a local city council trying to regulate international foreign policy. No way. 2, procedural. They actually have the power to do something, but they do it in the wrong way. Imagine them skipping a legally required public hearing before approving a massive construction project. And 3, abuse of power. They act so unreasonably or with such improper motives that a court just has to step in, like denying a business license purely out of personal spite against the applicant.
To understand how judges decide exactly when to step in, we turn to a famous quote from Lord Steyn. In law, context is everything. This is known as the principle of relativity. The level of court interference depends heavily on the context of the decision being made. Think about it. The law shouldn't impose the same strict, intense legal controls on an official managing high-level international foreign relations as it does on, say, a parole board official trying to lock someone in a prison. The stakes are entirely different. Context dictates the appropriate level of due process, and courts carefully calibrate their review based on how deeply the state's action impacts individual rights.
Finally, Section 6, the limits of the law and what the law cannot do. There is a truly crucial distinction here between good government and responsible government. Good government is just, it's efficient, it's compassionate, and it actively makes the community better. But here is the hard truth. Administrative law cannot magically guarantee good government. It can only guarantee responsible government. It ensures officials are accountable, that they follow the rules, and that they're restrained from arbitrary action. If a government follows all the correct procedures and stays perfectly within its legal limits to implement a terrible, uncompassionate policy, well, administrative law often cannot stop them. It enforces responsibility and procedure, not inherently good policy.
And this tension brings us to a final, really provocative thought. If unelected judges can use administrative law to strike down the actions of an elected government, all in the name of the rule of law, who is truly in charge? It is a delicate, sometimes fragile balance of power between those who govern and those who judge. It's the ultimate tightrope walk of democracy, and it's something every single citizen should keep a really close eye on. Thanks so much for joining me for this explainer, and keep questioning the rules of the game.